of anger so that I do not lose my footing when I come back to the service. And in respect, I submit towards the most eloquent statement written of Archbishop's Laws of England for the edition, volume 17, paras 13 and 14, where the court said, or where it is said, that the legal burden is the burden of proof which remains constant throughout trial on the prosecution. It is a burden of establishing the facts and the contentions which support the party's case, so that at the conclusion of the trial he has failed to establish this to the appropriate standard, he will lose the case. I also rely on the Supreme Court Canada, R vs. Figures 1997, Supreme Court Report, volume number 3, 320. The court held in criminal cases an accused that proceeds presumed to be innocent. Similar has been held by Lord Diblock in the case of Walter vs. Republic 1969. Because it's a long judgment, I'll just go to the pertinent areas, and once you get the judgment, it's 120 pages, you read it. The case is facing 5 counts. The first one, the offense of child stealing, contrary section 1741B of the Penal Code. The particulars are on diverse dates between 20th day May 2002 and 19th day of August 2004 at Mountain View Estate, house number 226 in Nairobi, within Nairobi area, jointly with others not before the court, with intent to deprive an unknown parent or guardian the lawful charge of a named child, alias EODE, a child under the age of 14 years, of the possession of the said child, Herbert, the said unnamed child, knowing him to have been so taken, detained, or enticed away. Second count, the same dates under the same section of the law. The difference is the name of the child, MAD, and number 3, same section, same offense, the same dates. The name is RAK. Number 4, same section, same dates, and the same place. The name is NGD. And number 5, same section, same dates. The child here is JGD. This is my analysis. It is now cast in stone and founded in many jurisprudential decisions so often repeated and yet bear reputation that throughout the web of English criminal law, and indeed within our jurisdiction, one word and threat is always to be seen, and that is the duty of the prosecution to prove the case accused person is guilty, subject to the defense of insanity, and subject to also any statutory exceptions. If at the end and on the whole of the case there is a reasonable doubt created by the evidence given by either the prosecution or the accused person, the prosecution has not made out the case, and the accused is entitled to acquittal, so that no matter what the judge or where the trial, the principle that the prosecution must prove the guilt of the accused remains, and no attempt to whittle it down can be entertained. Now, the section under which the accused is charged reads as follows: any person who with intent to deprive any parent, guardian, or other person who has the lawful care or charge of a child under the age of 14 years of the possession of the child is or harbours the child, knowing it to have been so taken or enticed away or detained, is guilty of a felony and is liable to imprisonment for 7 years. Now, having familiarized myself with the facts, the law, and the authorities cited by the rival counsel, and to contextualize the exposition of the analysis, the design of the issues for determination are set out in 10 subheadings. In event I do not make specific reference to any of the cited cases by both counsel, it is not that it is wanting in substance. Number one, it's important to define who is a child. It's paramount first and foremost to define a child. Under Article 2(6) of the Constitution, a child means an individual who has not attained the age of 18 years. According to Black's Law Dictionary for the edition, a minor is a person who has not reached full legal age, a child or a juvenile. And a child is defined as a person under the age of majority. In the Children's Act, Section 2, a child is defined to be any human being under the age of 18 years. Under Article 2, the African Charter on the Rights and the Welfare of the Child, ratified by the Republic of Kenya on 25th July 2000. A child means every human being below the age of 18 years. The United Nations Convention on the Rights of the Child defines a child as every human being below the age of 18 years, unless under the law applicable to the child majority is attained earlier. Kenya ratified the Convention on the Rights of the Children on the 31st July 1990. It is therefore clear that the definition of a child is universal. Now, with this backdrop in mind, the issue is whether the prosecution established that indeed the subject's victims here were children under the age of 14 years. Tom Ojola, PW number 9, is a dentist at the University of Nairobi School of Dental Science, and in his testimony took the court through the process of assessment of age. Applying all those parameters, he did confirm that all the subject children in 5 counts were indeed under the age of 14 years, as evidenced by the assessment reports for each of them. It must be recalled that even though Mary Deya had the certificates for the children, she was not called as a witness to produce them, and in any event, the children were not born in those facilities. Therefore, the age assessment is as good as birth certificates. Number 2, the definition of stealing. Section 268 of the Penal Code gives a definition of stealing and provides under Section 1, therefore, that a person who fraudulently without claim of right takes anything capable of being stolen or fraudulently converts to the use of any person other than the general special owner, therefore, of any property is said to steal that thing or property. In our case here, the term stealing is a question which I regard as a well-known academic. Number 3, the other issue is who is a complainant. By way of comparison between a property and a child being stolen from the general special owner, I understand that there must be a complainant who moves the law claiming parentage, guardianship, or any other form of lawful care of the victim. Equally, I'm cognizant of the defense submissions that there was no complainant who testified in the matter, claiming any of the children, and in any event, over 100 people who went to the police station to lay a claim were unable and turned away. So the next obvious question is, who is the complainant in the matter? This is quite some controversy as to what the word complainant means and its provisions, and in others where the word is used in Criminal Procedure Code. The Criminal Procedure Code does not define the word complainant. The word that is defined in the interpretation part of the CPC, Section 2, is the word complaint, to mean an allegation that some person known or unknown has committed or is guilty of an offense. The word complainant is no doubt to me derived from the word complaint, and it could appear to me that that's the person who makes the complaint. The Black's Law Dictionary, 10th edition, defines a complaint to mean the initial pleading that starts an action in civil cases, and in criminal cases, the formal charge accusing a person of an offense. So, initiation of criminal proceedings under criminal procedure is provided for under Section 89, which reads, a quote, proceedings may be instituted either by making of a complaint or by bringing before a magistrate of a person who has been arrested without warrant. 2, a person who believes from a reasonable and a probable cause that an offense has been committed by another person may make a complaint, therefore to a magistrate having jurisdiction. Number 3, a complaint may be made orally or in writing, but if made orally, shall be reduced to writing by the magistrate, and in either case shall be signed by the complainant and the magistrate. 4. The magistrate, upon receiving a complaint or where an accused person who has been arrested without a warrant is brought before him, shall, subject to the provisions of Section 5, draw up or cause to be drawn up, and shall sign a form or charge containing a statement of the offense with which the accused is charged, unless the charge is signed and presented to the magistrate. Now, in the case of Republic vs. Judith Achola Mulala, 2019, the word complainant, the court, while defining the word complainant, had the following to say: "It is my understanding, therefore, that the complainant within the context of Criminal Procedure Code could be that person who initiates the complaint that is envisaged under Section 89 of the Criminal Procedure Code. That complaint or charge is what initiates the criminal proceedings. Under Kenyan criminal justice system, criminal proceedings are initiated in court by the Director of Criminal Prosecutions, and it is that office that conducts the actual prosecutions. My understanding, therefore, is that the complainant is the prosecutor who stands for the Republic or a state in the criminal proceedings. Proceedings are started, continued, and terminated at the behest of the state through the prosecutor. It is the state through the prosecutor that is the party to criminal proceedings, and the matter is styled as a dispute between the state and the accused person. Reference, therefore, to a complainant in Criminal Procedure Code must be reference to the prosecutor, the initiator of the criminal case. The complaint envisaged in the CPC is not that made by the victim of the crime with the police. The police may refer to the information they receive from a victim of crime as a complaint, and that they may even refer to the victim to the extent as a complainant, but those words used in the CPC are not used in that context. They can only be construed in the narrow context of the information laid before a court by the person initiating the criminal matter formally in court, and refer to that person. I have read and reread the provisions of Criminal Procedure Code, and I am not persuaded that the word complainant refers to anything more than the person who initiates the cause in court through a complaint. Equally, there is this case of Mary Juma Gilbert Deya versus Republic 2014, while addressing the issue of a complainant, the Honorable Judge said the following: the complainant in this case is stated in the charge sheet as the Republic of Kenya through the Kenya Police Criminal Investigation Department. So the DA is a subject of the Republic, notwithstanding the parent or the guardian are unknown, that child is not stateless. Query the case of Savage and Hemorrhage Shah versus R 1960, East Africa, 562. The court held that it is not fatal to omit the name of the owner of the property. A conviction based on a charge that did not name the owner of the property cannot be quashed on that premises, so long as the property is proved to have been stolen. As it were, therefore, my holding is that the Republic of Kenya is the general complainant in this case and represented by the prosecutor. The fourth issue is whether the prosecution case was found on direct evidence or indirect. Undeniably, the children were collected from house number 226 Mountain View, while in possession of Mary Deya, and in the absence of the accused person, it was Lillian Kiamba PW 25's evidence that as at 19th August 2004, when the recoveries of the subjects were made, the accused was in the UK. Equally, CAB Chief Inspector Fatuma was among those who caused the raid house of house number 226, and at the time, the accused Gilbert Juma Deya was not present. In any event, there is no contestation that the accused was out of the country at the time. Clearly, the prosecution founded their case on the doctrine of recent possession and the principles of circumstantial evidence, and direct evidence is ruled out. The fifth issue is to consider the doctrine of recent possession. Isaac Nganga Kahiga and another versus Republic. It is trial law that before a court of law can rely on the doctrine of recent possession as a basis of conviction in a criminal case, the possession must be possibly proved. In other words, there must be positive proof, number one, that the property was found with the suspect, number two, that the property was possibly identified to be that of the complainant, thirdly, property was stolen from the complainant, and lastly, the property was recently stolen from the complainant. So the proof as to time has been stated over and over again, will depend on the easiness with which the stolen property can move from one person to another. The Canadian case of R versus Morgan 2013 ON Supreme Court 1522 is worth considering in this discussion. In that case, it was stated, the doctrine in nutshell allows the trial of facts in appropriate circumstances to draw an inference of guilt of theft or other crimes linked to the theft if it is shown that the accused is in unexplained recent possession of stolen property. The inference may be even made when there is not any other evidence of guilt. Equally, Supreme Court case of Canada Republic versus Coelic, 1988. McIntyre, judge for the majority, set out the principles that is used both in England, in the English and Canadian jurisdictions. Similar holding in Bulgaria Moses and another versus Uganda. Also Hassan versus R 2005 Kenya Law reports. Also in Maungi, Katano Maungi versus Republic 1989. Kwali Neri Otieno Arumu versus Republic 2006 Kerar. Paul Mwitarubi versus Republic, also in Kisumu High Court, Court of Appeal. Kinyati versus R 2004 Maringi versus Republic, and many others. Now, when I come to circumstantial evidence, it means evidence that leads to proof a fact indirectly by proving other events or circumstances which afford a basis of reasonable inference of the occurrence of the fact at issue. The circumstance should be of the conclusive nature and the tendency, and they should be such as to exclude every hypothesis that the one other than the one proposed to be proved. So circumstantial evidence is evidence which enables a court to deduce a particular fact from the circumstances that have been proved. Such evidence can form a strong basis for proving the guilt of an accused person. Now, Taylor, R versus Taylor, Wave and Donovan, Justice Hayward said this: it has been said that the evidence against an applicant is circumstantial. It is, but circumstantial evidence is very often the best evidence. Evidence surrounding circumstance which by intensified examination is capable of proving a proposition with the accuracy of mathematics. It is not the derogation from the evidence to say that it is circumstantial. Now, for both recent possession doctrine and circumstantial evidence, the following must be satisfied before one can conclude that a person is guilty. Number one, the circumstances from which an inference of guilt is sought to be drawn must be cogently and firmly established. Number two, those circumstances should be of a definite tendency, unerringly pointing towards the guilt of the accused. Number three, the circumstance taken cumulatively should be form a chain so complete that there is no escape from the conclusion that with no human probability the crime was committed by the accused and no other. Number D, this level of circumstantial evidence unerringly points to the guilt of the appellant. Now, in respect to the case and having assembled all those decisions, various propositions have to be deduced for the doctrines both to apply. For recent possession, the four parameters to be established: proof of ownership, recently stolen, and found in actual possession of a suspect. Knowledge that the property is in the custody of another. 2, inference is permissive and not mandatory. Number 4, when an accused gives a reasonable explanation whether it may be true or not, these doctrines do not apply. Number 4, there has to be no existing circumstance which point to another person other than the accused person. Now, having said that, I have issues which makes me a little bit uneasy with this circumstantial recent possession. Number one, it was a prosecution case that, having established that the house number 226 is jointly owned by the accused and the one married Deya, and from whence the subject children were recovered, and constructively the accused was in possession. Additionally, the prosecution held that on the basis of the evidence of Dbn 19, Emmanuel Grammar Simiyu, producing XP number 54, being the accused travel history with the 6 entries tabulated as 20th of April 2004, 26th April 2004, 27th April 2004, 5th July 2004, and the 8th of July 2004, while he was departing from Jomo Kenyatta International Airport, all go to indicate that the accused must have known that the children were in his house. The defense on the other side position was that on recoveries, the accused was in the UK. At the time the subject were recovered from their house. On travel history of the accused, the dates do not fall or tally with the dates that the offences were allegedly committed by the accused. And in any event, Section 12 of the Parts and Registration Act says that no person shall be entered in the register as the father of any child, except either at the joint request of the father and the mother, or upon the production to the registrar of such evidence as he may require that the father and the mother were married according to law or in accordance with some recognized. The position of the court in this respect is this. House number 226 Mountain View Estate is jointly owned by the accused and Mary Deya. But at the time the children were recovered from the ring, Mary was arrested and charged with the offense of stealing of children, and she was acquitted. At the time, the accused was in the UK. However, the prosecution case is that the accused, being a co-lessee of the house, was constructively in possession of the subject children. Now, according to Oxford Dictionary, the term constructive possession occurs where one does not have physical custody or possession, but is in a position to exercise dominion or control over a thing. Equally, under Oxford Dictionary 2nd edition, defines the word dominion to mean title to an article of property which arises from the power or disposition and the right claiming. Wilker versus Westcott, 73 Texas 129, 11 SW 157. However, the prosecution in their submission used the term constructive possession to refer to the accused being in possession of the subject children on account of title document to house number 226 Mountain View Estate. This was, of course, an error construing the term constructive possession law to mean being in constructive possession of the children. I say so because Section 4A of the Penal Code is deliberate in the meaning of the word possession. It says to be in possession of or have in possession includes not only having in one's own personal possession, but also knowingly having anything in the actual possession or custody of another person. Now, having denied knowledge that the subject children were in the house number 226, that he never knew the children were in the house number 226, it behoved of the prosecution to prove that the accused had knowledge that Mary Deya, Rose Kiserem, and Miriam Nyeki were arrested from the house, had the subject children in his house. Number two, the fact that the accused traveled frequently into the country does not necessarily infer that he had come to steal the subject children or abet crime. So that even if he went to his house upon coming in the country, that is not the basis to infer that he knew the children were in the house. The reason is, take the first scenario for example. Suppose he met them or he did not meet them. How can knowledge be proved indirectly? The second scenario, suppose Mary Deya had joined a certain cult without the knowledge of the accused person, and assuming that the accused was getting into the country without knowledge, could she still retain the children in the house? Traveling into country per se and going into the house or not is not a substitute of linking knowledge on the part of the accused to the subject. I say so because of Ad versus Taylor by Lord Edward C.J., who said, and the part I wanted to concentrate is, intensify the examination capable of proving a proposition with the accuracy of mathematics. Number 3, the state relied on the registration of birth and the birth certificates to hold a view that indirectly the accused knew the existence of the children. PW number 3 produced XP number 5, and for Elijah P. Juma, entry number 9, which indicated whether Mary was married, the father is not indicated. However, the mother is indicated as Mary Deya. In the capacity form, it is marked as parent. For Miriam Adongo, the name of the father is indicated, but on whether Mary is married, the father is not indicated. Note so that in respect to the two children, they were already born on the same day, 20th May 2002, and it's not possible that the name of the father can appear for one and not the other, and yet they were born on the same day at the same time. In respect to Naomi Gilbert Deya and Joshua Gilbert Deya, the registered form, as the witness said, is completed with a pre-printed word, parent, who can be either a mother or a father. It does not say who of these two. XP number 5 on the signature part, the word Juma is in block biro ink, and he cannot tell whose signature it was. PW number 3 was unable to place the accused at the hospital where the said registrations of parts took place, and the signature, which had XP number 6, was in capital letters as Juma. He did not know the owner of the signature, and as such, it was crucial to have the handwriting examined. PW number 3 was a civil registrar from the person registration, so it was crucial to have the handwriting examined by handwriting expert under Section 48 of the Evidence Act. The belief that the name of the accused appearing on the certificate is evidence enough to link him to the children is excavated by the evidence of Beck Akinyi Nyanya, PW number 23, who said that on 20th May 2002, Mary Deya and another lady went to her clinic carrying 2 infants, appearing to be the accused, appearing to be 2 months old, and at the time Mary Deya was not accompanied by the accused, Gilbert Juma Deya. Additionally, the witness said that he had not been sent by the husband. In any event, the accused was never facing a charge of making false documents or giving false information to the public servant. Number 4, I believe that the state relied on the evidence of Valerie Susan Tomlinson, who testified from UK as PW number 24, as part of an inference because the subjects in those DNA profiles which was taken in the UK was examined, but they are not part of the subjects which are in the case before the court. The witness made a finding that they were excluded, those 4 children were excluded from being biological children to the accused and Mary Deya. However, the court was not informed or told they were subject of criminal proceedings in the UK, they had been adopted, or they were under investigation in respect to the offense of child stealing or human trafficking. This information was so sketchy, and the court may not make any adverse inference from it. Number 5, it was critical to adduce the evidence of communication between Mary Deya and the accused person. Further, to have a tight or accurate inference, as accurate as mathematics, it was crucial that all call logs or any form of communication be adduced in evidence between the accused and Mary, that indeed the two communicated shortly before the children were recovered on the 19th August 2004. This reasoning is also supported by the decision of the Republic Colleague, which I've just mentioned. Number 6, having recovered the children from the house and custody of Mary Deya, Rose Kiserem, and Miriam Nyeki, and in the absence of the accused, who admittedly was in the UK, it was incumbent also upon the prosecution to either call any of these ladies in the house or any other from the house as witness to shed light on the relationship of the accused to the children and how they landed in their possession in that house. Section 143, Evidence Act, is very clear that no particular number of witnesses shall be called in absence of any provision of the law. To the contrary, be required for the proof of any fact. And so, in Donna de Machiwa Chilo versus Republic 2009, the court stated the law as it presently stands is that the prosecution is obliged to call all witnesses who are necessary to establish the truth in a case, even though some of those witnesses' evidence may be adverse to the prosecution case. However, the prosecution is not bound to call plurality of witnesses to establish a fact. But where this is very critical, the evidence adduced clearly establishes the prosecution case and the prosecution withholds a witness. The court in appropriate cases is entitled to infer that had that witness been called, his evidence could have tended to be adverse to the prosecution case. This is the holding also in R. Paskinkering Arab Koske, 1949 East Africa, also in the case of Kenya versus Uganda, 1972 East Africa, and also in Benjamin Mbowa Gidao versus Republic, 2011, Kenya Law Reports, Julius Kalewa Mtunga versus Republic, 2005. Now, having failed to place the accused in house number 226 Mountain View when the children were covered, it was still a burden on the prosecution to circumstantially place him there. Given the fact that at the time of recovery, 3 ladies were arrested, including Mary Deya, Roski Serem, and Miriam Nyeki, and none of them was called as a witness to give an account how the children landed in that house, the court is entitled to draw an inference that had they been called, the evidence could have tended to be adverse to the prosecution case and favorable to the defense case. Number 7, it is common ground to both the defense and the prosecution that at the time the subject were covered, the accused was in UK. So the issue is, as I understand the defense, is the accused is raising a plea or a defense of alibi. Charles Sanjare Hamusi versus the Republic. Court of Appeal stated, an alibi raises a specific defense, and an accused person who puts forward that alibi as an answer to the charge preferred against him does not in law thereby assume any burden of proving that answer, and is sufficient if the alibi introduces in the mind of the court a doubt that is unreasonable. Case also among the Republic in that holding, together with R versus Sukasin, and also Victor Mwendo Mulinge, together with Karanja Republic 1983. The prosecution did not report the accused's defense on alibi. I say this because the indirect evidence to connect the accused to the offense was wanting. The burden of proof remained still. The prosecution disapproved the alibi. Finally, the accused was charged on the suspicion of committing the offense by the fact that Mary Deya had been charged and convicted in the High Court criminal case number 97 of 2011. And on the assumption the circumstantial evidence could suffice, given that there was a list from where the accused from where the subject children were recovered was co-joined with Mary Juma and the accused person. However, the Court of Appeal has said, time and again, an example, Joan Jevchisawi versus Republic, that suspicion may be strong, but this is again with clear and settled rules of engagement. Prosecution must prove the case against an accused beyond reasonable doubt. This was also the holding Court of Appeal in the case of Mary Wanjiko Ishira versus Republic, Appeal number 17, 1998, that suspicion, however strong, cannot be a basis of inferring guilty which must be proved. In the end, it is true the prosecution made a lot of capital out of a number of circumstances in a bid to establish the accused was guilty. But that evidence does not satisfy the legal requirements of circumstantial evidence to warrant the conviction of the accused, and ultimately make a finding that the prosecution has not proved their case in all the counts beyond reasonable doubt, and they acquit the accused person in all the counts under Section 215 of the CBC and they set him free, and Desert was held back. Ask him, what was the security?
Your Honor, thank you very much. I'm not present. We have such a accused person, and we're very much obliged with that document. We had placed a title. We placed a title for security.
Title?
Yes. So the title was 10 million as per the directions of Justice. We pray that particular surety be discharged. Okay. And handed over to them.
All right. The title will be released to the reposter and the surety is discharged.
We seek to also pray that if the court be pleased enough, you could serve as a rather furnish and certified copies of your judgment, the proceedings, which are reference and records as well. We shall undertake to pay the requisite charges.
And one of the state will also be seeking copies of the same.
The study, do you pay requisite fee or you get it for free? Because you are part of the government, you don't pay. Same to be supplied to both of you.
Thank you very much for that.
All right.
Thank you.
All right.
That's good.
All the time.
You don't know whether you have a copy right now?
Oh, no. We have
Hallelujah.
silence.